There are packets available for everybody. For those of you who are attending, who are watching this remotely, the information that's in the packet is also available to you online. And if you have questions, make sure that you send the email to us so that we can answer those questions. Please be sure, for all of you who are asking questions here, wait till somebody with a microphone comes to you so that those of you who are watching remotely can hear the question. Parking, we will validate the parking for CalSTRS members, so that's the only way that, otherwise you'll have to pay with a credit card. We actually have a very full agenda, and the one thing that's unusual about today is, and we really need to stick to our schedule, the investment committee of the board is meeting at 12:30 in this room. So we're gonna make sure that we get done by 11:45, more or less, and we would ask that so that we can set up for the board meeting at 12:30, that when we are done, to please leave the room so that they can get organized. I know people, and it's fine if you want to hang out or go next door. That room's not being used, I don't think, this afternoon. Carmen, is it? Carmen disappeared on me.
It might be because there's a...
There.
It might be used because there's a lot of interest in the conversation that's taking place in the investment committee this
Right, but in terms of the
afternoon,
setup, though.
But I don't think there's any setup
Yeah,
issues
so
for it.
if there's some conversation you want to have out in the hallway or whatever, feel free to, or the cafe, whatever, but we do ask that you please leave the boardroom as quickly as possible so they can get set up. So in terms of the agenda, we'll start with the update from Danny and from Mary Ann on just what's going on with legislation in the very few days that the legislature's been in session for this year. Then an update on CalPERS' update on, well, actually, after that, just so you know, I think we were going to do it after, weren't we going to have a discussion on the CalSTRS implications? That's after the CalPERS one, I believe. Okay, so first one is getting your questions answered on the CalPERS side of implementation of AB 340. After that, then we'll have then whatever follow-up questions are on the CalSTRS side of implementation on AB 340. And what I want to caution you, and I will caution you at the time, is that we're going to sort of divide the implementation into two pieces. One is what the bill actually ended up saying and how we are implementing it and how you must implement it. And we also want to give you a preview of what we think may end up happening later on this year as they do cleanup on the legislation. But please be sure that what Joycelyn tells you is not what the law is. What Bill tells you is what the law is. So when you're thinking about what I have to do, what Bill says is what you have to do now. What Joycelyn is going to tell you is what might happen in the course of the year. And then we'll open up the open forum discussion and then talk about the agenda for February. Anything else that you want to make sure that we cover in the agenda? We're really trying to focus this on AB 340 to get those questions answered because we didn't have enough time last time. So please try to limit the discussion to that. But is there anything else you want to make sure that we cover? Scott, Peggy, anything you want to start with? Okay, so let's start with Danny and Mary Ann. Danny, you want to go first in terms of, I'm sure there's a huge number of bills that have been introduced in 7 days, so go with it.
Well, I'm not sure. We probably just have the same one bill to talk about because there hasn't been a lot happening so far. They have named all the committee members of the PERS committee, so that's a good sign. So that means that the one bill that we have, SB 13, which is the urgency bill to clean up some of the technical mistakes in AB 340, hopefully they can start hearing that fairly soon this month and get that fixed. At least from our perspective, that bill does include some important things. And I think there's basically 5 items in that bill that are important to CalPERS, and I think these are mainly things that were drafting errors. We don't see them as actually changing the intent of the bill or changing how we implement the bill. They have a provision that for judges that kind of clarifies what provisions apply to judges and which ones don't. They made some clarifying changes to. They kind of used the word, there's this new term that they've included, new employee and new member, and they've kind of, a couple places they said new employee, and I really think they meant new member, and so they've fixed that, which is helpful. They've added legislative employees to the bill. They said that they mistakenly left out legislative employees from the bill, and they've added them back in. So we just assumed that they weren't, legislature doesn't like to do anything to themselves, so we thought it was on purpose. But they're saying it was an accident, and so they are including the legislative employees. So all new legislative employees will also have to pay half the normal cost. They also, I don't think it impacts the school employees, but for the state employees, they go into what's called this alternative retirement plan for their first 2 years, and so that is being sunsetted. The bill originally had a July 1st date of sunsetting it, and now they've moved it back to January 1st to coincide with the PEPRA date. So, and then the last thing, there was an issue around some safety industrial disability. They added a new benefit for state safety for industrial disability, and they left out a word that could create a higher payment than they're really entitled to, and so they've made those changes. So, we see these as all kind of really technical cleanup, drafting errors that they're working on. There probably are going to be some additional changes added to this bill, and I guess we can talk about those later too when we get into the regular implementation process of AB 340. But those are the main things that we see in this bill. I know that they had a goal of trying to get this accomplished by the end of January. I'm not sure if that is still feasible. Like I said, they do have the committee members set, but they are looking at adding some additional changes, and I know that they're having conversations with the administration as to what those changes should be, and trying to get everything signed off before they actually put it into print, because I think once they kind of get the bill settled, they want to move it through as quickly as possible. I'll just also add that we have a housekeeping bill. We did take an item to our board in December to introduce our housekeeping bill. It has a handful of items, nothing that I think are earth-shattering or would cause any problems. And I don't know if you've looked at that agenda item. We have not put that bill into print yet, but that should be coming out here probably in first part of February. The main pieces in there that may affect you is that we are going to kind of give the board the authority to change the process if you get health benefits through CalPERS. Right now, it's basically you'd adopt a resolution. We're trying to coordinate it with our reorganization now that our health branch and our retirement folks are all kind of in the same area. We're going to try to streamline that so it's one contracting process. And so we will be changing the way we do our health contracting, and there'll be a contract besides a resolution. The other thing is that we are looking to right now, if you retire and you choose to get an EFT or paperless check warrant, we still mail you the receipt unless you opt out. So we're looking at changing that process to try to get more people to opt out of getting that receipt because I think we have 90% of our folks get a paperless check, but only 10% of those people have opted out of getting the receipt. So we spend $200 million a year mailing out receipts to folks that are getting a electronic check. So we're looking at ways to kind of to stop that, get more people, push people to just check it online, sign up to our CalPERS, and so we've made a change in our law that will give our board the authority to kind of make that change gradually. A couple other things in our bill don't impact school employees or schools, so I will not go over them, and I'll turn it over to Mary Ann. I don't know if she has anything else to add about SB 13 or anything else.
Good morning. Happy New Year. As Danny said, SB 13 is the only bill that CalSTRS is tracking right now, and it is an urgency bill to take care of some things that needed to be taken care of related to AB 340 from last year. As far as CalSTRS, there's only one or two provisions in there right now. One of the major ones is that it clarifies the share of normal cost for new employees. As Danny mentioned, we do anticipate that the bill will be amended to include any additional cleanup items related to AB 340. And then Member Account Services and Joycelyn and CalPERS will be giving some updated information as to the implementation of AB 340. One of the other things that we've been working on, you may recall last session, SCR 105 was signed. That was a resolution that encourages CalSTRS to work with advocates and stakeholders to develop some sample funding scenarios to submit to the legislature. The working group has been meeting and has come up with about 11 options to further refine, and they'll be discussed and shared with the board at tomorrow's meeting. And the end result will be to submit to the legislature at least 3 options to address our funding by February, those options to be submitted to the legislature by February. So that group is continuing to meet. As far as sponsored bills this year for CalSTRS, we will have possibly 3. One will be a technical housekeeping measure. One will be similar to a provision that's included in CalPERS housekeeping, and that's to authorize CalSTRS to make electronic delivery a default for some forms of communication unless the member opts to or requests to receive a printed copy. And then the third one.
Just let me add that CalSTRS last year implemented the electronic-only payment advices. So for those individuals with direct deposit, they're already getting an electronic copy only of their payment stubs. And CalPERS, I think, is modeling their practice after what we did a little bit, and members have to opt in to receive paper. So we went live with that in the last February-March timeframe. So what we're talking about doing for our electronic only, the primary focus would be on the electronic only retirement progress reports or annual statements, which is something that CalPERS has announced to at least its state employees that they're doing for the current year. So that's where we're going with the electronic access, hoping that we encourage members, I think, of both systems to take responsibility for managing their information by opening their MyCalSTRS or their MyCalPERS accounts and using that as a vehicle to understand their benefits, make whatever changes they need to make to their demographics and account information, and own their own information.
And the other sponsored measure would be to expand the board's authority over some senior management classifications that would allow us to recruit from a broader candidate pool. Are there any questions?
The other thing, I don't think this was mentioned, but another bill, which won't be necessarily our bill, but we expect to be introduced, is apart from the SB 13 to deal with the sort of the urgency issues of cleanup. We anticipate another bill to do the more routine aspects of cleaning up SB or AB 340 that don't need to take effect right away. So you'll actually see 2 AB 340 related bills that affect CalSTRS, one of which has been introduced, the other one hasn't yet been introduced.
I just wanted to add some information. What Peggy was just mentioning, that at our office here at Orange County, we have similar thought process where for all, we call it employee information system, and where we have all the employee information like their W-2s, all their stubs for last 3 years, whether they are direct deposit or not, because when they file taxes, 3 years, 3 months, whatever they have to correct, it's always available. So I just wanted to let you know. Thank you.
There's a question here.
I was just wondering, for STRS, for you to get clarification on setting the rates, that's not a bill, that's just getting clarification? Because there was some sort of question in our last meetings whether or not you could change the rates, because apparently it's in code that this is what the rate is, and that was one of the questions before. So is it just getting clarification, the board has that authority?
Let me answer. No, the clarification is legislation. What was meant to be done with respect to the new member is that the board will set the normal cost of the new benefit formula, and by virtue of the legislation, that will set the member contribution rate.
Okay, so it doesn't have to be in a bill. We wouldn't have to worry
It's in
about.
a bill that says that. It's a bill, that's the clarification, is that they did not, the board does not act to set the rate directly, the contribution rate. It sets the normal cost, and the legislation says that normal cost, the member pays half of it.
Oh, okay, so that was in the bill that just got, the PEPRA bill.
But
Okay.
it wasn't clear whether or not we're supposed to actually set the contribution rate or not. It's just clarifying. It's a relatively minor point, but it had a big deal to do with the process.
Okay.
So, but it will be cleaned up in legislation to make that clear.
Okay, so there will be something to clean that up, and it'll be through the legislative process?
Yes,
Okay, so
right.
we would want to monitor that.
Right.
And what about STRS recognizing other pension plans? Did you say that was in one of the bills? Because aren't you?
That will be reflected, I believe, in the routine, is that in the urgency bill? Is that likely to be in the urgency bill and the routine bill?
Concurrent membership?
Yeah.
Likely, we're thinking it might be an emergency.
It might, so, just so that people can hear, we're expecting that may end up in the SB 13.
So I just want to add that CalPERS will also be running a conforming bill that is a non-urgency. So we'll have things that will be helpful that are in SB 13 that'll be passed on an urgency basis, but then we will also be making changes to the PERL. Mainly, SB 13 is making changes to PEPRA. Changes that need to be done in the PERL we'll be doing in a conforming bill, which will just go through the regular process, and it'll probably be a very, very large bill. The biggest issue is our Tier 2, and we've figured at least 26 government code sections that need to be amended to make some changes to Tier 2. So, we'll probably have a 100-page bill, if not larger. And then I should probably add, I actually missed on our housekeeping bill, probably the most important thing, and because I think we talked about it last month when we were here, but there was a CalPERS staff that talked to you about the PERS-STRS right of election and how we were going to make that change to allow those folks that are not vested to make this PERS election if their break in service was, I think, less than 120 days. So that is also in our housekeeping bill, or will be in our housekeeping bill when we introduce it.
Okay, so now Anthony could talk about the implementation on the CalPERS side of AB 340.
Good morning, everyone. For those of you who don't know me, I'm Anthony Sweeney, Chief of the Benefit Services Division at CalPERS. And I've been asked to just come recap some of the stuff that we've talked about before on PEPRA, maybe answer some implementation questions that you have. I'll probably reach out to Danny and some of our functional experts that are in the audience as needed if we get too in-depth. But what I want to talk about is just touch on some key points that were presented last meeting by Danny, talk about the resources that are available to you, cover a few of our circular letters that recently went out. Danny talked about SB 13, I think, so I just put some key points in there, but we can skip over that and then revisit some of those FAQs that we're getting often and just recap what's in those and some canned answers that we provide that help just provide a basic education. So the key points that we covered last meeting, we talked about definition of a new member under PEPRA. That's one of the other ones we'll revisit. We talked about the mapping of the current safety formulas to new formulas and how that worked. Again, that's not super critical to you folks. We talked about how to define the normal costs and how we calculate and kind of the components of that normal cost. And then we talked about some of the general provisions of PEPRA. So we can revisit any of those as we need towards the end. I think we'll have plenty of time. So some of the resources that are available to you, in particular, to now that we've reached 1/113, and we're now focused more on implementation as opposed to what's coming. We do have my CalPERS training classes that will teach you how to do enrollments now with some of the new components of the PEPRA laws, payroll reporting, and how those impact you. So those training classes are available to sign up online. And if you have any questions, I think we have some of our training staff out here can help answer more specific questions on that. We have our pension reform impact page, and we try to put as much on it as we can to link you to the key information items on PEPRA. The circulars are also online. I did notice they're not under the pension reform impact page. They're under the circular letter link. We may look at maybe providing an extra link to there so you can have one consolidated homepage for all that information, I noticed as I was putting this together. So we're going to cover those circulars, but you can get those online if you didn't have a copy or need more of the forms or attachments that came with those. There's also a summary of the changes. These are really was the high level summary of the bill and the important sections of the bill and how those impacted, whether they impacted classic and new, or only classic or only new. And then we have our FAQs, and we continue to add to these FAQs as we bring them out of these meetings, out of our various teleconferences. We've been gathering those and adding to them. And you can go out there. We had some comments that, I never know what's new on there. But if you look at the FAQ, it'll tell you when it was posted. So if there's any new information on there, it'll have an updated date with that extra detail. But we're posting new questions all the time as we get them, because we know everybody has similar questions. And then I guess I reinforced here that there's my CalPERS training classes to help you with implementation. So let's cover some of the recent circular letters that are out there. 200-05512. This was kind of our stab at really starting to talk about some of the implementation details. Again, we released this in early December, so things are changing all the time, and we're learning more. So it doesn't have everything in it, or all the specific details. It was built to handle schools, state, and public agencies. So, it's broad in terms and may not get to your specific issue, but it does give a high-level overview of how we're implementing PEPRA and the various sections in PEPRA. And so we talk about the benefit formulas, the contributions, a little bit about pensionable comp, and we followed up on that. I'll talk about it in a minute, and then working after retirement and those rules. And then we released 200-06012 on December the 11th. And this let the schools know what the 50% of normal cost, what the new member contribution rate will be for the new members, 6%. Talks a little bit about how it was calculated. It tells you when the next round will come out, and around May of 2013, the new rates will go to the board, and that'll determine the new 50% normal cost for the next fiscal year. Circular letter 200-06212 had some initial details of pensionable compensation items for new members. Again, it's not the complete package yet, but it tried to give you some key factors of what will continue to be pensionable compensation for new members, right? So it must be regular recurring pay. It must be available to all members in the group or class. These are all terms you're familiar. It must be performed during normal work hours. It must be available in the publicly available salary schedules. So those are our key, kind of 4 key components of things that will continue to be reportable to CalPERS that may be outside of the normal salary, but still part of monthly regular recurring pay. We also outlined some things we know aren't reportable. For the most part, we've kind of been saying CalPERS was the model, and this legislation really enforced kind of our model on some of the county retirement systems who may have had a little broader definition of special compensation. So some of the things that outline that aren't allowable, like car allowances and overtime, CalPERS already adhered to. What it did take away that we had before was uniform allowances and a broader view of bonuses. And we did allow some bonuses, and some things are just termed confusing, I guess. There's a broad term. Bonuses is on a lot of special comp when it truly may not be a bonus. It may be regular recurring pay once they reach a certain milestone. And so those are the type of items that staff are still reviewing, and we're preparing our regulations probably in the March timeframe. That'll get proposed and would really detail what is allowable and not allowable. And then with that circular letter, there was also an attachment that said, here's the kind of things that are allowable and continue to be allowable. So it's kind of the things we had were kind of no-brainers, and then we're still working on a handful of items, and then we want to drive it home with a regulation to clarify. So our next circular was 200-06-312, and this was a couple new processes that we put in place, and it kind of covered a few things, but one was the impairment of the MOU, and I got a couple questions on this ahead of time, so maybe I'll address them now. So if you have an existing MOU, you can say that MOU is impairing the new members, and so for the extent of when that MOU expires, the new members can still be covered by that MOU, even though the new law says you cannot have employer-paid member contributions, the member rate is 50% of the normal costs. Some of these existing MOUs, if they're deemed impaired, would continue to cover these new members for that period of time for those provisions. And so this circular letter kind of outlined that process, and we're really looking to the employer to tell us that the MOU is impaired. Every employer might look at it a little bit differently, and we don't want to be the ruler of what is and is not impaired. So we ask you to complete this form, send it in to us. The key thing is when that MOU expires, and we'll continue to monitor, because just an example is, we would expect that all new members that are enrolled and become new members on or after 1/1/13 would not have employer-paid member contributions reported to us. And now we get them in a bucket on the payroll file that identifies them as employer-paid member contributions. We would not expect to see that. We'll be running reports on new members and say, hey, what is this EPMC we see for this new member? Well, we'll immediately go to your employer file and look for this impairment, and we would expect to see that impairment on file and look at that end date and say, okay, this is covered by this impairment, but we shouldn't see him after this date. If we don't have that impairment on the file, then we're going to contact you and ask you why you continue to report employer-paid member contributions, that you're out of compliance. So that's just an example of why we need this MOU impairment. There was some questions, and I can't answer them all. I just got them yesterday, and I need some time to research. But they're, unless Danny can help me out here and has the magic bullet. But the question was, hey, we don't we're just operating under this contract that really hasn't been renewed and doesn't really have an end date, but we continue to work. Is that considered an expired MOU? Do you have a solid answer on that? And I don't know the answer. I can't give you a 100% answer to that. So it's something we'll need to research and we'll put out on our FAQs once we do a little more research with our legal office and some of the impacted stakeholders and see what the right answer is. So the other questions seem to be geared more towards classic members. And one was non-represented employees, and then another was about when the MOU expires, then EPMC goes away. And so the clarification I need to give there is, remember your classic members can still be entitled to employer-paid member contributions and the existing member contribution rates that are in place. So regardless, when that MOU expires, you can create a new MOU. I mean, the thought is you'll have a new MOU covering the classic employees and then one covering the new members, right? So you can still renew EPMC for your classic membership. So I'm not sure if there was anything more to that, but again, when that MOU expires, even though you have that impairment, now your new PEPRA members can no longer be covered by EPMC, are now subject to the 50% of normal costs, and then anything else you're including in that MOU going forward. So, Francis?
So if you have an MOU for EPMC and you have a new member come in because the MOU hasn't expired, is that new member subject to the old rate or the new rate?
That's where we're leaving it up to the employer to say that new member's impaired by the existing MOU. If you are stating they're impaired by it and you submit this form, then we will expect that they are treated like classic members, at least for the member rate and the EPMC until that MOU expires. If you don't deem they're impaired and they're subject to the new, we're going to go with what you tell us. Hi, Joey.
My question's on the EPMC. You're talking about EPMC reportable as a special comp,
So,
not the one where we've split.
No, I'm talking about both, really. I
Well-
mean, so you have the base EPMC where the employer actually pays part of the member contribution or all of the member contribution. And then we have what's called reporting the value of that EPMC, which is reported as special compensation that increases the member's final comp. Even though you can, so the MOU would cover the first part of that. As long as it's in place, you can still pay the member contributions for that new member if it's impaired until that expires. You can, because we've eliminated special compensation in that sense for new members, you can no longer report the value of that EPMC after January 1 for those new members. So you can pay the member contribution, but you can't report the value of it.
Thank you.
We have a group of employees that are represented by our superintendent, like management, no contract. So how does that affect for the EPMC if they have EPMC? There's no MOU.
Yeah. I think that's something we're going to have to look into with the other question, right? If there's no existing contract or MOU in place, I mean, my gut tells me that there's nothing that can be impaired that covers them. Again, that's my gut. not going to 100% say that that's the answer. We want to put something out on our FAQs. That's when we kind of solidify the answer. So I would say the new members are subject to the new provisions of the law, but we will confirm that. It's kind of like that situation. It's a little bit different from the situation where they have an MOU, but it ran out and we keep operating under that MOU. It's a little bit different, so we need to find the right answers.
I have a question about the MOU also. For new members, I understand that if the MOU states that the employer pays 100%, then we still pay 7% for the new employees or new members. Otherwise, we would pay 6%. Because our state's 100%.
Yeah.
So does that mean we pay 7% for them?
Yeah. Yeah, they would pay 100% of the I mean, if you're saying they're impaired because of the existing MOU, then they're also paying the classic member rate. So yes, you would pay 100% of that 7% until the MOU expires.
Okay, because we have a district that doesn't feel comfortable signing this form, and they believe that that the contributions should remain the same for anyone in a similar classification. They're not feeling like it should be at 6% or that they should be even dropped afterwards, because they're feeling like these employees are in a similar classification and they should have the similar benefits.
Well,
so
that's great. They can take that up with the governor, I guess.
Okay.
But I mean, that's the whole intent of the legislation.
I know.
Treat these people differently. So, you know, we can talk to them more about it. They can call
Okay.
our office and we can put them in touch with the contract people. I don't know how to get people quite over that
I know.
fear or concern, but
Okay, so when the MOU expires, or let's say the contract with the union is revised, is it from the new effective date, or is it from the date that they've made this decision to, make a change to the MOU in some other way?
I believe I would say it's when the new agreement starts.
Okay.
And again, let me clarify too. It's not only if the MOU expires, but it's also if you go in and make any
amend it.
changes or amend that current MOU, that terminates it for the new employees
that
as well.
date that they
that would be a case where, right, it's terminated now because we're amending it and we're
For July
making a new
1st.
one going forward, as
So-
opposed to one where, sure, I'm agreeing to new bargaining, say July 1, and I ratify that in April or May, but it's still not effective to July 1.
So it would stop in April or May, not July 1.
Two different things here. I think I
Okay,
got you
I'm
confused
confused.
there. If in April, let's say you have a June 30th expiration date. In April, if there was immediate changes needed and you went back to the bargaining table and you agreed to amend your MOU immediately, then that would terminate the MOU at that point in time, and the new members would be subject to the new rules.
Okay.
If you went in to negotiations and in April or May you came out with a new agreement that was going to be effective July 1, then it would wait till June 30th to expire, and then July 1 the new members would be covered by the new provisions.
Okay,
Does that help?
thank you.
Now there's a couple questions up here.
Hi, Anthony.
Irina.
I wanted to know, the way my understanding is, even though for EPMC, we honor the new, let's say 7%, but only 6% will go in employees' account and the other 1% will offset employers. Is that true?
I guess, do you want to help me out here?
One of the
Yeah,
PERS staff told me that, and I want to
Yeah.
verify that.
Yeah, this
Because
is
if the employee
our-
withdraws money, he is only going to get 6%,
yeah,
even though
right.
district paid 7.
So what we're saying is that we're establishing the new member contribution rate for these new members at 6%. However, if do you want to help me out here? Maybe I answered I think maybe I answered
Yeah,
the
I
previous
know.
question
That's why I wanted to.
incorrectly, because we're setting up the new 6%. So when they're paying 100% of the member contribution, I got myself confused. They're paying 100% of the 6%, right? That's right.
So
that's
not
right.
7%? then?
Yes.
So it
Yeah.
will be 6%?
I would, right, I think the employee, I think that letter went out and said that the employer contribution rate, or the employee contribution rate for your new members is 6%. So then depending on what your MOU says, your MOU might say we pay 100% of the rate. It might say we pay 3%.
Or we pay 7%.
Or we pay, if it pays 7%, then I think you're just gonna, 6% is just gonna go into that member's account, and that other 1% will,
So always in employees' account, only 6% will go for new members. That's what I wanted to clarify.
Yes.
Is that,
yeah, I think that's,
Okay.
that's my understanding. If that's
Yeah.
different, we will send something out to you, but my understanding is
okay,
the member rate is set at 6, and that's what will go into their account.
okay. And Anthony, you were just saying that we will send those certification, those MOU
Yes.
thing to you guys. Once we send the information to you, are we going to hear anything from you guys acknowledging or any information?
Do you know the answer to that? I don't know if we're going to be, who's handling the incoming certifications?
Is it
Comp review or contracts? Okay. And we don't have anybody from contracts here, huh? I don't know the answer to that, Vina, so we'll get back to you on
Okay.
that. Like, I don't know if we'll confirm that, thank you, we received your.
and it is good to go and
Yeah,
all that
right,
stuff?
right.
Okay.
Yeah.
Because then we are always in the dark. We don't even know you received it.
Yeah, I mean, we'll make sure that gets in place.
Okay.
puts
And one
that in
other
for you.
question on EPMC is that I just heard you saying that once the MOU expires and the new employees, if they are still reported as EPMC, it will flag. How will you know?
Well, we will be running reports on the
No,
back
but
end.
how we report the same way, everything to you?
No,
so-
because there's 2 buckets now, right, on the payroll file. It tells us if it's tax-deferred member paid
Right.
and tax-deferred employer-paid member contribution.
Okay.
So we can see the money in the 2 individual buckets, and we'll be running
That's-
reports
yeah.
that will help
I-
us determine
Yeah, I
are
haven't looked
people
at
in
the screen
compliance.
for a long time, and I just was wondering how will you know?
That's
So
a
that
change
the
with my CalPERS. We didn't
Okay,
know that
so there
before.
is a bucket.
Yeah, it all
Okay.
fell in the tax deferred bucket, and we didn't know what made up the difference,
Uh-huh.
but now we do.
One thing it's a request, it's not a question, while I have the microphone in my hand.
I need to get out
Is-
my pen, Vina.
Okay, it's a
Special
request is
request.
that you are one agency, PERS, I know you're big, and we do understand you have multiple different kind of employers, and you have 3,000 employers that you send memo to. Out of those 3,000 employers, there might be 3, 5, 10 people per employer reading your memos that you send. So it could be 10, 15,000 readers, the memos you send. It will be, I know it's a additional burden on you guys, but it's a help to 15,000 readers. If you can just break down the memos for school employers separate than safety, or because every time we read, we have to read, first thing we have to read multiple times
Yeah.
those memos, and then we have to say, oh, this doesn't apply to us, this doesn't apply to us. It will be burden on one agency, and it will help 15,000
Yeah.
readers. This is just a request.
Yeah.
But we do appreciate the information.
And we understand, and we're trying to do that. You know, I mean, Pepra was kind of a unique situation, and we're trying to get a lot of communication out and
Yeah, and we do
creating the
understand.
three
It's
different.
just
and,
whenever it's the right
Yeah.
time, if you guys can start
Yeah.
working in that direction. Thank you.
We will,
Thank
as
you.
we can.
Thank you.
Okay, I have two things I want to clarify because they seem to be in conflict with information from the teleconference.
Okay.
One being that EPMC as reportable special compensation. I specifically asked that question during the teleconference and was told that it would be covered the same way as EPMC, whereas if the MOU were impaired, it would be okay to let it go until expiration.
Terrence, do you have any input on that, or is that something we should take back and make sure we're all on the same page? I know before we were saying it wasn't reportable because it was kind of outside the bounds.
I don't know if I have a great answer, but the one thing I would point out is that we're talking about new members. So if you have EPMC in your contract and you report it as compensation, I mean, it's never going to count towards the retirement. I mean, this person, because in 2 or 3 years, it is going to go away. Eventually, it will go away because EPMC will go away, so there'll be nothing to report.
Well, my concern is of us, our technological system, what the issue is going to be, is trying to, again, parse it out even further in the two different groups. And if it's only going to be for the extent of the contract, I'd rather just really have them be the same until it ends. So is it going to be an error in the system?
Let us get that. It won't be an error.
Okay.
But let us get back to you with the solid answer on that, because I was kind of responding from previous where we kind of landed, but there's been several developments. So let me work with comp review staff and make sure we get a good answer for you on that.
Thank you.
So
And one other thing with the effective date of the MOU versus a ratification date. Say, and this is common, that we have a district who's in mediation over a contract that's already expired, and they've basically been in a holding pattern under that. If they're not able, if they haven't already ratified, but it has an effective date of July 2010, is that the contract we're looking at to see if it's expired, or has that boat sailed?
I think, again, that's something that kind of fits in that boat of, what do I do with this expired contract that people are still operating under? Right. Is that an expired contract for new member purposes? And I just think that's something we need to go get a solid answer on. It's coming up more and more, so
Right.
I think we'll make sure we get you that.
Okay, thank you.
So you understand what Danny's saying too on that other issue. The members are going to pay for that and never get any credit for it. But again, it is hopefully a short period of time.
So Anthony, Carmen has some questions from somebody remotely connected.
Okay, and then after we take these questions, I'm going to move on and then we'll get to more questions.
I think you already answered this, but I want to get it on record. It's from Cheryl from Merced County regarding MOU impairment. If new PERS employees are in positions similarly situated to other employees, would they pay 7%? And she said, I also read that similarly situated employees are determined by retirement formula, which makes me think they will pay 6%. And this is not related to EPMC. So I think you already answered that question, but just want to make sure I got it on record.
Yeah, and there's some mixed stuff in there, I think, but if she didn't mention when the MOU expires or if there was an impairment. So if there is a new member that they will go into 2% at 62, the new member. However, if the MOU impairs them, they would pay they would be set up at 6%, but the EPMC could cover that 6%.
Just want to clarify, she's just started with regarding MOU impairment, so I didn't know if that would help. Okay.
So maybe they are impaired by that contract. So they're still entitled to the EPMC until that MOU expires.
And I was just going to add that as far as the similarly situated employees, CalPERS is taking the route of defining that as similarly situated means you're in the same retirement formula. So that's how we're getting around school employees. You have two employees sitting next to each other, but one's in the 2 at 55, one's at 2 at 62, and they're not similarly situated. Similarly situated is employees within the same retirement formula.
Thanks. So the other piece of that circular letter we didn't get to is the member self-certification for reciprocity. So as you know now, when a new member comes to us, comes to the employer, we also have to consider that reciprocal employment if they had any. And if they had any within the last 6 months and they were a member of that reciprocal system prior to 1/1/13, it may qualify them for classic membership. Therefore, we've now built the system to ask these additional questions for you to input. We're asking you to have the member complete this form and certify this form that they had these specific dates with the reciprocal system. What system was that with? And then, we kind of leave the due diligence up to the employer about how deep you want to go with validating that. Are you going to call the reciprocal system? Are you going to ask the member to provide you additional paperwork to confirm everything they put on that self-certification? We kind of leave that up to the employer, but we ask them to have that on file for if an audit occurred and all of a sudden we notice every one of your new members is all of a sudden classic because of this reciprocal membership. We want to make sure you have those on file, and then our auditors would probably do some due diligence to ensure those certifications were valid. So hopefully that's pretty self-explanatory. It is required. Yes.
Is it required by each employer to fill the form for every employee, even though they are for every employee?
No, if you're enrolling the member into classic membership based on their reciprocal status, then it would be required, right? If you meet with the member and they say, I have no reciprocal membership, then I don't know, is there a no, I don't have?
It does have.
So we're
no.
asking them.
Yeah, it does have.
Is it like
no.
a notice of exclusion form then?
It is, exactly.
Yeah, on the form, there's 3 options. Were they never a member? Were they a member but they retired from that other system? And are they a member and they're coming from a reciprocal retirement system that they left their funds? So just technicality, right now it's not required, but we are developing regs to require the form. So it's a tool for the employers to use to validate whether they are a classic or a new member.
Right. Okay. Just wanted, because sometimes districts, they don't like when they have a hiring package and they have already 10, 20 forms in there. So they are just not very happy about it. But of course it's needed and we understand.
Yeah.
Thank you.
Yeah.
I wanted to just see if there is any penalty if they didn't do the form.
It's similar to the notice of exclusion where we say you should have your member fill this out because it protects you if they ever come back and said, hey, you should have enrolled me. I worked at some other agency prior and I didn't tell you about it.
To speak directly probably to the regulations that you'll be drafting and to clarify on the employer instructions for the form, it says that the employers must provide the form to all new employees upon hire. Now, if we're hiring somebody who doesn't qualify for membership, then this is not really timely.
True.
So would it be upon hire of a qualifying employee or? Because if we get it on file now and then 2 years later is when they qualify, then
It's not going to matter because
it's
they had a
not.
break of greater than 6 months.
Maybe. Or
So-
maybe it's concurrent.
True.
We can't make assumptions
True.
like that. So-
Again, once you have the form or you provide the form when they become hired or they become member, we're going to have to be looking at dates in order to validate the information that you put into the reciprocity section on my CalPERS when you're enrolling them. The system's going to derive what they are, classic or new member. If you feel there's a discrepancy because of that, then you need to contact us for us to look deeper into it.
Okay. Also, there's a typo on the form.
Eligibility.
Yes.
Taken care of. That was changed, and also there was 2 retirement systems that were left off, and that's been corrected, and the forms are updated.
Okay, thank you.
And I have provided some copies of the attachments in the back of the room. So if you wanted to pick up one of those forms, you haven't seen it, they're back there. So let me move forward, and then we can answer any additional questions. So some upcoming circulars and resources we plan on implementing. We are working on a working after retirement circular letter to kind of better address. We have some high-level stuff that's in the main circular letter, but we didn't really drill in. And so, right before we implemented PEPRA, a few months before, we implemented SB 1021, I believe it was, that changed some of the working after retirement rules. Then PEPRA came in, and we're still trying to flesh out what sections of PEPRA are still supported in the PERL, which ones were overridden, which things in SB 1021 live on. So we're fleshing that out and trying to make those clarifications. And as soon as we do, we'll get that circular letter out. In the meantime, the one thing we do want to get out to you is kind of a sample resolution for if you have an exclusion to the 180-day or an exception to the 180-day. So we want to give you a sample resolution to give you some guidelines of what should be covered when you present that to your board. Make sure what you give to us is kind of a complete package that we receive, so we can go ahead and give you the authority to move forward with that exclusion. Sherry? You're so well trained.
Okay, I'm getting daily contacts about this. So how soon will you have this sample resolution out to us? Because I'm talking daily.
Okay.
And we have to take it to our board, which is only, monthly. So that's another delay.
Right.
And on top of that, there's the thing about the independent contractors, if there's not a common law employee-employer relationship. And so I've downloaded the questionnaire. Who can I send it to at PERS to determine whether there's a common law relationship so that we're not, the 180-day doesn't there too. Like I said, daily contact about that.
Okay. So, in the meantime, you should work with our working after retirement team. I don't know if you work with Rosanna Castaigne et al., but okay, well, yeah, and Liz works for Rosanna. So that's fine. That's the right group to touch base with. So I would say we hope to get that out very soon. But in the meantime, work with that group, and they can give you immediate feedback on anything that's kind of urgent, needs to be expedited. Yeah.
On the working after retirement, if you're retired as a classified employee from CalPERS and then you work as a substitute teacher, and should that be I'm getting conflicting responses through my CalPERS about if you're a CalPERS employer, but you're working in a certificated substitute position that doesn't qualify, that you don't elect STRS, do you report those hours to CalPERS?
I don't know the answer. You guys know better than I do.
You know, and so do you have to wait the 180 days? I mean.
No, because it's not under the same retirement system. Yeah. Oh, magic. Liz Burke is here to save me. Did you hear your name? I didn't see. Okay. So do you want to address any of what you heard?
Well, we're still working with our legal office and the group analyzing the impact of the PEPRA legislation and how employers are supposed to handle retired annuitants. And if the retiree is a direct contract with a CalPERS employer, then the common law control test doesn't apply. It would only be if the retiree is working through a third-party employer that we would be looking at that common law control test to determine whether or not the retiree under the third party is subject to the control of the employer. So we would want those contracts sent to the Benefit Services Division, and that address is in the Employment After Retirement booklet available on the website. It was just updated, available online for viewing and downloading. Then the other issue you brought up was the sample resolution. Yeah. And Anthony told you what is happening. We're still working on that. And then what was the other question? Oh, about the CalSTRS retiree who's working for a CalPERS as a substitute?
Other way around.
Okay.
CalPERS retiree who's going to work.
It's a substitute.
Yeah.
And they didn't elect CalPERS membership.
They're
STRS.
retired.
Okay. Unfortunately, that situation, I really am uncomfortable trying to give you a general response because we need to know the facts on the individual to make sure that person didn't elect a CalSTRS thing. So I would recommend you call the toll-free number, or you can email me. I know you guys know how to get emails to me because I get them all the time. Or you can email to Rosanna Castaigne. So it would be our last name, our first name, liz.burke@calpers.ca.gov.
We went to dot.
And then Rosanna is ROSANNA .Castaigne, CASTAIN @calpers.ca.gov. So can I go back and hide in the other room now?
I think we can find a seat for you out here somewhere.
Okay, I have the reverse of that question. You have a CalSTRS retiree who's coming back into a school setting and working in a non-certificated position as either an independent contractor or an employee of the third party. Because the duties they're performing are not creditable service for STRS, STRS doesn't want to see the reporting, and it doesn't apply against the earnings limit. But by law, they're in violation of employment in the classified position. Does that get reported to CalPERS so that it can be looked at?
Do you know this? I don't.
Actually, is this working?
Yeah.
I think I would want you to email me that question with a particular person because it was very kind of confusing. I'm sorry, but is that okay?
Sure. Yeah, let's deal with those case by case. Vina.
Regarding the independent contractors, I think I emailed also, and I'm checking that most of the time independent contractors, they use their TIN number, tax identification number. They don't use their social security. So we don't even know that a retiree is working as independent contractor. They are not on the payroll. They're not paid through payroll. They don't use social security number. So what will happen if we get audited and it's missed?
So I think we need to provide some guidance on that. It's still, and same with the issue of how do I compute the hourly rate that's for somebody who's similarly situated, or I don't think it's similarly situated, but working in a similar position.
So in the meantime, we shouldn't bother?
I will say, I do think it's on the employer to do due diligence to require that information so that you can monitor the situation. But, we haven't put that out in writing. We don't have guidelines of what you should be doing to make sure you're complying. But, if we do, if it turns out that we find out that member was working in an independent contractor direct relationship, we will follow the procedures as outlined in the PERL to reinstate that individual and take back all the money and, force them to report them back for that period of time.
Because as a county office, we don't want 40 files to come from 40 districts because they are not paid through payroll. So they give us the information and we plug it into our file. So we will have to ask the districts to enter in your system directly if they have an independent contractor.
Retired annuitants.
Yeah.
If that worked out, yeah. So
Just wanted to run by you guys.
Yeah.
Okay. Thank you.
We know it's a bit gray. Yeah.